Hello, everyone. This is Kristine Tungol with the Tungol Law Office. Today, we will break down this fairly recent USCIS memo regarding the policy on who can adjust green card status within the United States and who must go home to their home country to apply via consular processing to become a green card holder in the United States. This USCIS policy memo is just reiterating the fact with a long-standing immigration law and court decisions that typically those who are seeking green card status or permanent residency in the United States must file their application via consular processing. Their home country, apply via Department of State, and consular process it over there, file the documents, and be interviewed by a U.S. Department officer or a consular officer in order to obtain a permanent lawful residency or green card status here in the United States. Now, for how many years now, many of these green card hopefuls have been able to file their application while inside the United States. So this is called adjustment of status within the United States. What USCIS wants to do now is they want to reiterate the long-standing immigration law that most people, not all, most people must go back to their home country to apply for green card unless you can prove you have extraordinary circumstances. We're going to break down what that means, extraordinary circumstances. So as always, this is case by case. Your case is different from another person trying to apply because you have different fact basis. Your immigration journey is different from that other person. So we are going to tell you that it is case by case, and the more documents you have to prove that you may apply via extraordinary circumstances, the better it is for you. Now, these qualifying extraordinary circumstances are such as the following categories. Number one, U.S. national interest. So we have, for example, healthcare workers, researchers with specific skills, STEM teachers, public school teachers, all these skills that urgently needed for critical projects, vital medical research, care infrastructure, those that are absolutely essential to the U.S. national interest. They may qualify to adjust within the United States. The second one is if there is a national emergency and you as a non-immigrant worker have direct involvement in care during a national health emergency, you may also qualify to adjust your status within the United States. And the third one is personal compelling factors. Now, this is pretty wide as far as serious medical needs, you're a caregiver with responsibilities for U.S. citizens, severe financial losses caused by departure to your employment or your employer. You just have to show personal compelling factors that may affect the employer, that may affect a U.S. citizen, and those that are living in the United States. If you depart for an unspecified amount of time to complete your process outside the United States. So those are just some of the extraordinary circumstances that you may qualify to adjust your status within the United States. So this affects a lot of non-immigrants, right? If you are on a B2 tourist visa and you're here and you decide to stay and adjust your status here, this will affect you. If you come here on a student visa, F1, if you come here on other working visas such as B1 and those that do not qualify under the extraordinary circumstances, you might have to go home and to your home country and apply for immigrant green card via consular processing. Again, you have to talk to an immigration attorney because maybe there's a way that you may qualify to adjust within the US. But it is essential that you talk to someone before you pursue this and move forward with any type of application, especially if you are here on unlawful status, but you may qualify for a green card via an I-130 petition, a spousal petition, immediate relative petition to a U.S. citizen, right? If you are married to a U.S. citizen, but you arrived here maybe via tourist visa and that tourist visa has expired and you didn't exit the United States, you are here unlawfully. But typically, if you apply to a U.S. citizen, then you can cure that unlawful status by applying for spousal petition and then adjusting status to that of a permanent resident here in the United States. That used to be the case. But with this, it sounds like you might have to go home to your home country if you can't prove extraordinary circumstances. And so you have to go around the loophole of what do you do if you leave the US and you've overstayed for more than 6 months, for more than a year. Typically, you cannot come back for 3 months 3 years or 10 years. So that's called the 3 and 10 year bar. So all these things that would make your case unique to you, such issues unique to you, you really need to talk to an immigration lawyer before pursuing green card status application. The other factors for other non-immigrants that these will not apply to are those that are coming here, such as fiancé visa, right? You come here, essentially fiancé visa is for you to a path to a green card. You start the consular processing in your home country, and then you come here. And when you arrive here, you have to get married within 90 days and apply to adjust your status with Form I-485. This does not affect fiancé visa, right? Because your path is such that you need to file the 485 after you get married and get married within 90 days and then file the 485 after that. The other type of employment, non-immigrant employment, that this does not affect are those that is dual intent. What is dual intent? Such as H-1B. If you're an H-1B category worker, you come here with an H-1B visa or status. It is called a dual intent visa because it is your pathway to a green card, and that's always been the case. So in this case, if you are under H-1B, you could adjust within the United States, but it is such that it's not automatic. You also have to show not only the qualifying extraordinary circumstances, but you also have to show that there is no presumption of guilt, right? You come here on an H-1B visa, not to come here on a different type of visa and then change your status to H-1B, because then there's a presumption of guilt there for wanting to come here for immigration purposes. So there's no presumption of guilt. You come here on an H-1B visa. There is no status loss. So while you are on an H-1B visa and then you want to file for an immigrant petition and then you want to file from there for a green card to adjust your status to a green card holder, you have to be in lawful status within the whole time. So you cannot be overstaying even for a day or two. Your status has to be lawful the whole time you're here. Seamless travel while you are traveling internationally on a valid H-1B while your green card is in process, you have to make sure there is no risk of an immigration officer denying your entry over immigrant intent. And also H-1B extensions, you can stay here and extend all the way up to the initial period of 6 years. Beyond that, you would have to file the steps. You have to begin the steps of a green card process or permanent residency process so that you can go ahead and renew your H-1B status while your immigrant petition is being processed. So you can renew beyond the 6 years initial entry. while that's the case. There are also dependent considerations. The privilege of dual intent legally extends to H4 dependents. So while you're here and your family's here, family unification plays an important role. Your H4 dependents have strong evidence and strong ties to you, may adjust their status within the United States. So that is it. It's a lot to process. So we have also a sheet of paper here that showcases, that lists everything that I'm discussing with you today. But it is imperative that you consult with an immigration attorney to see what favorable options you may have to proceeding with your green card process beyond this USCIS policy memo regarding the adjustment of status within the United States versus the consular processing abroad. So we hope to hear from you. If you have any questions, please do not hesitate to contact us. And I hope that you're all doing well and have a